putting aside, Mr. Grossman, whether there's any realization requirement at all, I mean, there is quite the history in this country of Congress taxing American shareholders on their gains from foreign corporations. And you can see why, right? Congress, the U.S. government can't tax those foreign corporations directly, and they wanted to make sure that Americans didn't kind of stash their money in the foreign corporations, watch their money grow, and never pay taxes on them. So, there's a long, century-old history of these kinds of taxes on gains from your holdings in a foreign corporation. Why is this any different, and why shouldn't we understand that to be quite well settled, that Congress can implement those taxes and enforce those taxes for those purposes?
The taxes in that area have followed the pattern that I described of simply a taxpayer interposing a corporation between themselves and income that would otherwise be theirs. And those provisions
from the beginning,
it isn't. Those provisions from the beginning,
these are the same shareholders as in subpart F.
The difference is that those provisions have typically addressed things like passive income and related party transactions that are properly attributable to, say, a parent corporation. In other words, a parent corporation could own an income-generating asset itself, or it could simply shift that into a corporation, into a foreign corporation, and thereby avoid the income. And what the laws recognize is that just as in cases like Horst and Banks, that's effectively an assignment of income, and that it can be attributed to the person who, the parent corporation, for that reason, because the parent corporation is the one that controls the flow of the income as it's coming in. The MRT, by contrast, operates as a tax on property. It doesn't take account of any power that the shareholder had over the income as it was coming in the door to the corporation. It only takes account of ownership in 2017.
That seems to be an argument about timing. In other words, we have realization in this case, the entity realized income. The question then is attribution, and we've long held that Congress may attribute the income of the company to the shareholders or the partnership to the partners. And the only real wrinkle, I think, here is that it goes back and captures prior year's income.
I think there are two wrinkles. One is that with respect to those prior years, the statute doesn't require that the shareholders being taxed had any ability to control the disposition of the income in those years. That's a fundamental distinction. The second is that subpart F...
That's not true for the facts of this case, though, correct?
It is not true for the facts of this case.
But you're saying generally, yeah.
Well, I think it just demonstrates that this is a tax on property. In other words, do you own something on a particular date as opposed to what do you do in the past? Did you have that power in the past? But second, provisions...
Has been taxed year by year. Would that have been permissible?
No, and that's the second wrinkle, so to speak. In this... The MRT is the inverse of its predecessors in the statutes. All of the predecessors, like the foreign personal holding company provisions, as well as subpart F, focus on categories of income that are susceptible to being reassigned into the corporate form. Congress has never reached so far as to tax shareholders of foreign corporations on the active business income of those corporations.
Why is that different analytically? I mean, this was all part of a big change from a worldwide tax system to a territorial tax system, and this is one piece of that. But I guess I'm not sure why which kind of income is at issue matters for the ultimate analysis of whether the attribution is permissible.
Because all of these attribution schemes, going back to the very beginning, have focused on effectively the fraudulent or improper availment of the corporate form to avoid income. And they've always done that historically by focusing on particular categories of income that are susceptible to that type of abuse. Congress took that to the max as it amended subpart F over the years to capture more and more types of that sort of income avoidance. What's interesting is that subpart F says, you've captured the field, now let's get everything else. And the everything else is the active business income that's attributable solely to the foreign corporation's own legitimate business activities overseas. And so the shareholder in a foreign corporation stands in no different position with respect to that income than a shareholder in, say, Microsoft or any other corporation. This isn't the type of income that shareholder would, in the ordinary course of affairs or as a matter of reality, be able to shift around into a corporate form and thereby avoid receiving it themselves. I also want to address just the difficulties that the government's interpretation would raise with respect to the current tax code. As I noted, the tax code already reaches the full extent of Congress's authority under the 16th Amendment. And if the government is right, therefore, that certain novel categories of income, certain novel categories of what had heretofore been regarded as unrealized income or unrealized appreciation were subject to taxation under the 16th Amendment, then those would already be subject to taxation under existing law.